Hello guys, welcome back again to Vance Empire TV. My name is Governor. So guys, straight into chapter 10. Chapter 10 talks of judiciary. You remember in these the three arms of government, we started with the legislature, then we went to the executive, and then now the last part of the arms of government is the judiciary. So today we're going to see how judiciary works and what's all contained in the judiciary. So this one, judiciary is divided into four parts. Part one is judicial authority and legal system. Then we have part two, which talks of the superior courts. Then part three talks of the subordinate courts, and then part four talks of the Judicial Service Commission. So I think this one is a bit short. I can handle it once. So straight into it, acha tuanze na judicial authority. So judicial authority is derived from the people and vests in and shall be exercised by the courts and tribunals established by or under this constitution. In exercising judicial authority, the courts and tribunals shall be guided by the following principles. Justice shall be done to all, irrespective of status. Justice shall not be delayed, because justice delayed is justice denied. Alternative forms of dispute resolution, including reconciliation, mediation, arbitration, and traditional dispute resolution mechanisms, shall be promoted, subject to clause 3. Justice shall be administered without undue regard to procedural technicalities, and the purpose and principles of this constitution shall be protected and promoted. Traditional dispute resolution mechanisms shall not be used in a way that contravenes the Bill of Rights, is repugnant to justice and morality, or results in outcomes that are repugnant to justice or morality, or is inconsistent with this constitution or any written law. Let's continue, guys. Independence of the judiciary. So the judiciary is also independent. If I could receive any direction from the executive or even the legislature, but they are interdependent. They depend among each other. So let's see about the independence of the judiciary. In the exercise of judicial authority, the judiciary, as constituted by Article 161, shall be subject only to this Constitution and the law, and shall not be subject to the control or direction of any person or authority. Ndio tunaisikia vizuri. So wakati jaji anahongwa, apewa kitu, anafinyiwa kitu, ana roll case against vile inafaa kwa sheria. What do we say about that one? Katiba inasema ukweli. So let's continue. The office of a judge of a superior court shall not be abolished while there is a substantive holder of the office. The remuneration and benefits payable to or in respect of judges shall be a charge on the consolidated fund. Subject to Article 168, Sub-Article 6, the remuneration and benefits payable to or in respect of a judge shall not be varied to the disadvantage of that judge, and the retirement benefits of retired judge shall not be varied to the disadvantage of the retired judge during the lifetime of that retired judge. A member of the judiciary is not liable in an action or suit in respect of anything done or omitted to be done in good faith in the lawful performance of a judicial function. Judicial offices and Officers. This is Article 161, judicial officers and officers. So these are the people who work in the judiciary. Okay. The judiciary consists of the judges of the superior courts, magistrates, other judicial officers, and staff. There is established the office of Chief Justice, who shall be the head of the judiciary. So that one, I think we understand that the Chief Justice is the head of the judiciary, and also the Supreme Court judge and the President of the Supreme Court as well. The Deputy Chief Justice, who shall be the Deputy Head of the Judiciary, and Chief Registrar of the Judiciary, who shall be the Chief Administrator and Accounting Officer of the Judiciary. So Chief Registrar hapo is the Administrator of the Judiciary and Accounting Officer. So huyu ndiye anadili na mambo ya mambo ya pesa kwa judiciary. The Judicial Service Commission may establish other offices of registrar as may be necessary. System of courts. The superior courts are the Supreme Court, the Court of Appeal, the High Court, and the courts referred to in Clause 2. Parliament shall establish courts with the status of the High Court to hear and determine disputes relating to employment and labor relations and the environment and the use and occupation of and Title 2 land. Parliament shall as well determine the jurisdiction and functions of the courts contemplated in Clause 2. The subordinate courts are the courts established under Article 169 or by Parliament in accordance with that article. Straight into Part 2. Now Part 2 talks of the superior courts, the one we've just read. So it outlines the courts, the superior court. We've talked of the Supreme Court, Court of Appeal, and the High Court. So let's see under the Supreme Court. The Supreme Court consists of a Chief Justice, who shall be the President of the Court, Deputy Chief Justice, who shall deputy for the Chief Justice and be the Vice President of the Court, and 5 other judges. So hiyo ndio number ya Supreme Court judges. So they are in total 5. 5 judges and Chief Justice and also the Deputy Chief Justice. So those are 7. The Supreme Court shall be properly constituted for the purposes of its proceedings if it is composed of 5 judges. So when it has 5 judges, that one, it is properly constituted. It can continue with its function. So hiyo ni quorum. Yeah, it means with 5 judges in the Supreme Court, quorum imefika, so they can have their cases heard. The Supreme Court shall have exclusive original jurisdiction to hear and determine disputes relating to the elections to the office of the President arising under Article 140 and subject to Clause 4 and 5 appellate jurisdiction to hear and determine appeals from the Court of Appeal and any other court or tribunal as prescribed by national legislation. Appeals shall lie from the Court of Appeal to the Supreme Court as of right in any case involving the interpretation or application of this Constitution, and in any other case in which the Supreme Court or the Court of Appeal certifies that a matter of general public importance is involved, subject to Clause 5. A certification by the Court of Appeal under Clause 4b may be reviewed by the Supreme Court and either affirmed, varied, or overturned. The Supreme Court may give an advisory opinion at the request of the national government, any state organ, or any county government with respect to any matter concerning county government. All courts and other than the Supreme Court are bound by the decision of the Supreme Court. The Supreme Court shall make rules for the exercise of its jurisdiction. An Act of Parliament may make further provision for the operation of the Supreme Court. Okay, let's see a Court of Appeal. Court of Appeal shall consist of the number of judges being not fewer than 12, as may be prescribed by an Act of Parliament, and shall be organized and administered in the manner prescribed by an Act of Parliament. There shall be a President of the Court of Appeal, who shall be elected by the judges of the Court of Appeal from among themselves. The Court of Appeal has jurisdiction to hear appeals from the High Court and any other court or tribunal as prescribed by an Act of Parliament. We are done with the Court of Appeal, straight into the High Court. There is established the High Court, which shall consist of the number of judges prescribed by an Act of Parliament and shall be organized and administered in the manner prescribed by an Act of Parliament. There shall be principal judge of the High Court, who shall be elected by the judges of the High Court from among themselves. So the High Court is headed by principal judge. Principal judge. Okay. Who is elected by the judges of the High Court from among themselves. So wanachaguana wenyewe kwa wenyewe who will be their principal. So that is it. Let's continue. Subject to clause 5, the High Court shall have unlimited original jurisdiction in criminal and civil matters. Jurisdiction to determine the question whether a right or fundamental freedom in the Bill of Rights has been denied, violated, infringed, or threatened. Okay, that's their mandate. Jurisdiction to hear an appeal from a decision of a tribunal appointed under this Constitution to consider the removal of a person from office other than a tribunal appointed under Article 144. Jurisdiction to hear any question respecting the interpretation of this Constitution, including the determination of the question whether any law is inconsistent with or in contravention of this Constitution. The question whether anything said to be done under the authority of this Constitution or of any law is inconsistent with or in contravention of this Constitution. Any matter relating to constitutional powers of state organs in respect of county government, and any matter relating to the constitutional relationship between the levels of government, and a question relating to conflict of law under Article 191 and any other jurisdiction, original or appellate, conferred on it by legislation. Any matter certified by the court as raising a substantial question of law under clause 3b or d shall be heard by an even number of judges, being not less than 3, assigned by the Chief Justice. The High Court shall not have jurisdiction in respect of matters reserved for the exclusive jurisdiction of the Supreme Court under this Constitution, or falling within the jurisdiction of the courts contemplated in Article 162, sub-Article 2. The High Court has a supervisory jurisdiction over the subordinate courts and over any person, body, or authority exercising a judicial or quasi-judicial function, but not over a superior court. For the purposes of Clause 6, the High Court may call for the record of an of any proceedings before any subordinate court or person, body, or authority referred to in clause 6, and may make any order or give any direction it considers appropriate to ensure the fair administration of justice. Straight to Article 166. Appointment of Chief Justice, Deputy Chief Justice, and other judges. Okay. The President shall appoint the Chief Justice and the Deputy Chief Justice in accordance with the recommendations of the Judicial Service Commission and subject to the approval of the National Assembly, and all other judges in accordance with the recommendation of the Judicial Service Commission. Okay. Each judge of a superior court shall be appointed from among persons who hold a law degree from a recognized university or are advocates of the High Court of Kenya or possesses an equivalent qualification in common law jurisdiction. B. Possesses the experience required under clause 3 to 6 as applicable, irrespective of whether that experience was gained in Kenya or in another common law jurisdiction, and have a high moral character, integrity, and impartiality. The Chief Justice and other judges of the Supreme Court shall be appointed from among persons who have at least 15 years experience as a superior court judge, or at least 15 years experience as a distinguished academic, judicial officer, legal practitioner, or such experience in other relevant legal field, or held the qualification specified in paragraphs A and B for a period amounting in the aggregate to 15 years. Each judge of the Court of Appeal shall be appointed from among persons who have at least 10 years experience as a superior court judge, or at least 10 years experience as a distinguished academic or legal practitioner, or such experience in other relevant legal field, or held the qualification mentioned in paragraphs A and B for a period amounting A and B above, the one that I've just read, amounting in the aggregate to 10 years. So those are the qualifications for one to become a judge of the Supreme Court, judge of the Court of Appeal, as well as a judge of the High Court. So let's see under the qualification of the judge of the High Court. The judge of the High Court shall be appointed from among persons who have at least 10 years. This one also must have 10 years of experience as a superior court judge or professionally qualified magistrate, or at least 10 years experience as a distinguished academic or legal practitioner, or such experience in other relevant legal field, or held the qualifications specified in paragraphs A and B for a period amounting in the aggregate to 10 years. Yeah, so those are the qualifications required. Well, let's continue. Tenure of office of the Chief Justice and other judges. A judge shall retire from office on attaining the age of 70 years, but may elect to retire at any time after attaining the age of 65 years. Okay. So hiyo tumeona hapo retirement age ya judges, if you didn't know, ni 70 years. Kama mwenyewe akifika 65 years na anataka kuretire, anaweza mwenyewe resign but now not in this our country, it's not easy usikie cases kama hizi. Mwenyewe ameamua tu kuresign after amefika 65, atangoja tu mpaka hiyo 70. Let's continue. The Chief Justice shall hold office for a maximum of 10 years or until retiring under clause 1, the one that I've read above, whichever is the earlier. So inasema hivi, Chief Justice tena yake ya ofisi years zile ya kwa ofisi ni 10 years from the time he was appointed to the time of his retirement, his or her retirement, for in the case of the one that we have right now, Chief Justice Martha Koome, either akae kwa ofisi for 10 years ama retirement imtoe kwa ofisi. So whichever that comes first. Yeah. For instance, aliingia akiwa, let's say ameingia akiwa na miaka 60. So atakaa kwa ofisi mpaka afike 70 years. Atakaa kwa ofisi for 10 years, the one that is allowed in the constitution. So inamaanisha tampata at the same time wakati anaelekea retirement yake ya 70 years. So this one hiyo itaingiana. But wacha turudi nyuma kidogo. For instance, ameingia akiwa na 50 years. Umeingia Chief Justice ukiwa na 50 ama hata 55. It means the first one is 10 years. So you are 50 years when you are getting in, so you retire when you are 60. So pia unapiga hesabu calculation na miaka zako. So I think hiyo ndio advantage wako nayo hapo. If the Chief Justice term of office expires before the Chief Justice retires under clause 1, the Chief Justice may continue in office as a judge of the Supreme Court. Okay. If on the expiry of the term of office of a Chief Justice, the Chief Justice opts to remain on the Supreme Court under clause 3, the one I have read above, the next person appointed as Chief Justice may be selected in accordance with Article 166, sub-Article 1, even though that appointment may result in there being more than the maximum permitted number of Supreme Court judges holding office. So most definitely you itabidi tu waende retire. The Chief Justice and any other judge may resign from office by giving notice in writing to the President. Okay, removal from office. Removal from office, how to remove a Chief Justice or any other judge from the Supreme Court. A judge of a superior court may be removed from office only on the grounds of inability to perform the functions of office arising from the mental or physical incapacity, a breach of a code of conduct prescribed for judges of the superior courts by an act of parliament, bankruptcy. Bankruptcy imekuwa msoto, amekuwa declared bankruptcy, imekuwa msoto. Incompetence or gross misconduct or misbehavior. Yeah, so for those ones, kina Harvey and Grand Muller Ahmed Nasir wamekuwa wakisukuma sana agenda ya kung'oa ajiuzulu Martha Karua Chief Justice, wamekuwa wakisukuma sana hiyo agenda. So these are the grounds wanafaa consider. So because they are lawyers, senior counsel, they have to consider all these for them to remove Martha Koome from office. Let's continue tuone hapo chini natuambiaje katiba. The removal of a judge may be initiated only by the Judicial Service Commission, acting on its own motion or on the petition of any person to the Judicial Service Commission. A petition by a person to the Judicial Service Commission under clause 2 shall be in writing, setting out the alleged facts constituting the grounds for the judge's removal. So hiyo ndio mbinu wenye Harvey wanafaa kutumia na Ahmed Nasir. Hiyo ndio wanafaa kutumia. Present a petition to the JSC, Judicial Service Commission. Then the Judicial Service Commission shall consider the petition And if it is satisfying that the petition discloses a ground for removal under clause 1, send the petition to the president. On your procedure, the president shall, within 14 days after receiving the petition, suspend the judge from office and, acting in accordance with the recommendation of the Judicial Service Commission, in the case of the Chief Justice, appoint a tribunal consisting of the Speaker of the National Assembly as chairperson, 3 Superior Court judges from common law jurisdiction, then 1 advocate of 15 years standing, and 2 other persons with experience in public affairs. Or, in the case of a judge other than the Chief Justice, appoint a tribunal consisting of a chairperson and 3 other members from among persons who hold or have held office as a judge of a superior court, or who are qualified to be appointed as such, but who in either case have not been members of the Judicial Service Commission at any time within the immediately preceding 3 years. 1 advocate of 15 years standing and 2 other persons with experience in public affairs. Despite Article 160, Sub-Article 4, the remuneration and benefits payable to a judge who is suspended from office under Clause 5 shall be adjusted to 1/2 until such time as the judge is removed from or reinstated in office. So bado huyo judge hata kama amekuwa suspended, still anaendelea kupata mshahara yake up to 50% wakati kesi yake inasikizwa. So these are the tenure of office and these are what they enjoy. Amesuspendiwa, yes, apigi job, but anapata salary yake up to 50%. Half of the salary anapata. A tribunal appointed under Clause 5 shall be responsible for the regulation of its proceedings, subject to any legislation contemplated in Clause 10, and inquire into the matter expeditiously and report on the facts and make binding recommendations to the President. A judge who is aggrieved by a decision of the tribunal under this article may appeal against their decision to the Supreme Court within 10 days after the tribunal makes its recommendation. The President shall act in accordance with the recommendations made by the tribunal on the letter of the expiry of the time allowed for an appeal under Clause 8. If no such appeal is taken, or the completion of all rights of appeal in any proceedings allowed for under Clause 8, if such an appeal is taken and the final order in the matter affirms the tribunal's recommendations, Parliament shall enact legislation providing for the procedure of a tribunal appointed under this article. Part 3. Subordinate courts. So let's see under the subordinate courts, which are these courts that are subordinate courts. Most of you, you've looked, tumepitia through the superior courts. Yeah. Tumeona ni Supreme Court, Court of Appeal, and High Court. So let's see under the subordinate courts. Ni courts gani hizi? Mahakama gani? The subordinate courts are magistrate courts, the Qadhi's courts, the courts martial, and any other court or a local tribunal as may be established by an act of parliament other than the courts established as required by Article 162, Sub-Article 2. Parliament shall enact legislation conferring jurisdiction functions and powers on the courts established under Clause 1. Let's continue. Qadhi's Courts, this is Article 170. There shall be a chief Qadhi, and such number being not fewer than 3, of other Qadhis as may be prescribed under an Act of Parliament. A person shall not be qualified to be appointed to hold or act in the office of Qadhi unless the person professes the Muslim religion and possesses such knowledge of the Muslim law applicable to any sects of Muslims as qualifies the person, in the opinion of the Judicial Service Commission, to hold a Qadhi's court. Parliament shall establish Qadhi's courts, each of which it shall have the jurisdiction and powers conferred on it by legislation subject to Clause 5. The Chief Qadhi and the other Qadhis, or the Chief Qadhi and such of the other Qadhis, not being fewer than 3 in number as may be prescribed under an Act of Parliament, shall each be empowered to hold a Qadhi's court having jurisdiction within Kenya. The jurisdiction of a Qadhi's court shall be limited to the determination of questions of Muslim law relating to personal status, marriage, divorce, or inheritance in proceedings in which all the parties profess the Muslim religion and submit to the jurisdiction of the Qadhi's courts. So Qadhi's court hii ni ina deal na mambo ya Waislamu, and because even the Qadhi himself must be a person who knows Muslim and understand Muslim. So sio mtu yote anaenda kuwa Qadhi's court judge huko in Uislamu. Part 4. This is Judicial Service Commission, JSC. Establishment of the Judicial Service Commission. The commission shall consist of the Chief Justice, who shall be the chairperson of the commission, one Supreme Court judge elected by the judges of the Supreme Court, one Court of Appeal judge elected by the judges of the Court of Appeal, one High Court judge and one magistrate, one woman and one man elected by the members of the Association of Judges and Magistrates. The Attorney General, 2 advocates, 1 woman and 1 man, each of whom has at least 15 years experience, elected by the members of the statutory body responsible for the professional regulation of advocates. 1 person nominated by the Public Service Commission, and 1 woman and 1 man represent the public. Yeah? Public, wananchi wa kawaida pia wanawakilishwa pale, with 1 woman and 1 man, not being lawyers, appointed by the President with the approval of the National Assembly. The Chief Registrar of the Judiciary shall be the Secretary to the Commission. Let's continue. Members of the Commission, apart from the Chief Justice and the Attorney General, shall hold office. Provided that they remain qualified for a term of 5 years and shall be eligible to be nominated for 1 further term of 5 years. Let's see the functions of the Judicial Service Commission. The Judicial Service Commission shall promote and facilitate the independence and accountability of the judiciary, and the effective and transparent administration of justice, and shall recommend to the president persons for appointment as judges. So hiyo ndio kazi muhimu sana ya JSC, hiyo ndio muhimu. Review and make recommendation on the condition of service of judges and judicial officers and their remuneration and the staff of the judiciary. Appoint, receive complaints against, investigate and remove from office or otherwise discipline registrars, magistrates, other judicial officers and other staff of the judiciary in the manner prescribed by an act of parliament. Prepare and implement programs for the continuing education and training of judges and judicial officers, and advise the national government on improving the efficiency of the administration of justice. In the performance of its functions, the Commission shall be guided by the following: competitiveness and transparent processes of appointment of judicial officers and other staff of the judiciary, and the promotion of gender equality. So let's see an article 173, judiciary fund. So the judiciary fund ni pesa ya judiciary, because for them to run all these, to pay the judges, and the judicial officers, they need money. So that's why we have the judicial fund under this article 173. So what's tuone how they get their money. Okay. Judicial fund shall be administered by the chief registrar of the judiciary. So kwa nini chief registrar ndiye anashughulika na mambo ya judiciary fund? Because tumesoma pale mwanzo that the chief registrar is the administrator and accounting officer of the judiciary. So that is why yeye ndio anahusika na mambo ya judiciary fund. Na kama if you remember, some years back, Gladys Boshule was the chief registrar, and he was accused those years, like some 7, 8 years ago, before he became the women rep of Uasin Gishu. He was the chief registrar before ingie kwa siasa. Alikuwa accused sana, he was accused of irregularities in this judiciary fund. So this was one of the things then zilifanya achujwe from the judiciary. Okay, let's continue. The fund shall be used for administrative expenses of the judiciary and such other purposes as may be necessary for the discharge of the function of the judiciary. Each financial year, the chief registrar shall prepare estimates of expenditure for the following year and submit them to the National Assembly for approval. Hii ni kazi ya chief registrar. Kwa anajua do yote nyiko kwa judiciary na ile wanahitaji, so wana prepare the budget, then ana present to the National Assembly. So, and that is why you can see he or she might be involved in all these irregularities in the judiciary. Upon approval by the National Assembly, the expenditure of the judiciary shall be charged on the consolidated fund, and the funds shall be paid directly into the judiciary fund. So anytime budget inasomwa, judiciary pia inapata share yao from the tax ya wananchi. Judiciary pia inapata share yao, ile imekuwa presented in every financial year, ipresentiwa kwa parliament with the chief registrar. So budget ikisomwa, allocation yao inatumwa kwa account directly ya judiciary. Nani ana run, nani ana man hiyo account? Chief Registrar. Then finally, Parliament shall enact legislation to provide for the regulation of the fund. Okay. Wow, that comes to the end of judiciary. So we've seen under the judiciary, we've seen the judiciary, how it works, who are the members of the judiciary. We've learned of the superior courts. We've said the superior court. We've learned from the constitution that the superior court are the court of appeal, high court, and the supreme court, and the subordinate courts as well, the magistrate courts and the court marshals, and not forgetting the Kadhi's court. Guys, I think that one imekuwa very exciting, so we call it a day for this one. But then wakumbushe guys, please tell a friend to subscribe to Vance Empire TV. The name is Vance Empire TV and my name is Governor. Thank you for watching. See you next time.